This program is brought to you by Emory University.
There are three things a person will die for: their faith, their freedom, and their family. And it's those three things that Professor Helen Alvaré has been deeply involved in her scholarship, in her advocacy, and in her counsel to various organizations within and related to the Catholic Church. She is professor of law at George Mason University, coming there from Catholic University of America, where she had served. She's been working very closely on fundamental questions at the intersection of family law, of constitutional law, and of First Amendment religious freedom. She's waded in courageously and brilliantly into the deep culture war questions that have divided us over the last 25 years, as citizens, as communicants, as members of different households, as we think through the fundamental questions of what marriage looks like, what family looks like, what contraception looks like, what the right to reproductive freedom looks like, as we think through the responsibilities that a church has in tending to its congregants, in tending to its tradition, in being stewards of teachings that go back to a scripture. And in the role that Professor Alvaré has played, she has taken the lore of the classroom and the lore of her books and articles so exquisitely wrought and brought those to bear in the Witherspoon Institute and its forum and force on conscience protection at Princeton University, in her work with the Catholic Women's Forum, which has given us a beautiful anthology of women's voices in the Catholic Church, in her counsel to the Pontifical Council of the Laity in the Vatican, in her advice to the U.S. Catholic Bishops' Conference, in her work with the United Nations and the Permanent Observer Mission of the Holy See. She's been able to be a bridge builder and a person who has taken the lore of the classroom and the lore of books directly into advocacy in an authentic way to the fundamentals of faith, freedom, and family. We are delighted to have the opportunity to welcome her here. Happily, this is not the first time she has been involved with the Christian legal studies work that we've been doing here, been involved in advising us on how to craft a new book series with Cambridge University Press, of which we hope we will have 2 or 3 volumes with her name on it in due course. And we're delighted to have the chance to hear about her war in the trenches, as well as at the blackboard. Professor Helen Alvaré.
Greetings, patient afternoon, people, and thank you for being here. And thank you so much, Professor Whitty, for organizing this, and Mr. McDonald. It's been a pleasure getting to know you a little and participating in one of these fora. It's wonderful for me to have listened to what has gone before. I so rarely get the opportunity to spend an entire day with scholars. As Professor Whitty has indicated, my work is at the intersection of scholarship, teaching, counsel, both now to Pope Francis on the matter of women and to the U.S. Catholic bishops. And because I know the importance of public communication, I'm also in very regular contact bringing scholarship to about 41,000 women who, without my really encouraging them much, have signed on to an initiative that I began regarding sort of a new iteration of religious women's freedom in the United States. I'm very grateful to the professors who went before me, and in particular to the last comment of Professor Hittinger about the down and dirty legal and political context, because that's often where I operate. Writing amicus briefs for the Supreme Court, writing scholarship for ordinary law journals, and also, again, trying to communicate that in particular to the American population. We know that the Catholic Church, which I work closely with, is a leading human rights thinker and actor. But today, increasingly and vociferously, it's often classified as a threat to human rights in connection with issues surrounding human sexuality in particular, particularly matters respecting contraception, abortion, and LGBT identity and behavior, to the point where some have attempted to shut it out of the debate as an irrational actor, or even an actor whose main intent is to violate human rights. Another response is simply to cabin the church's visibility, its interaction with non-co-religionists, by adopting restrictive interpretations of freedom of religion or conscience, or imposing legal requirements which are formally neutral on their face, but really mean that religiously motivated businesses and individuals cannot obey, such that they have no choice but to leave the marketplace. So today I'd like to address this situation in 3 points. First, to describe the conflict over matters of human sexual relationships in the arena of human rights between the Catholic Church and leading international, national, and interest groups. Then I want to review the commonly proposed explanation for this conflict. Next, I want to propose an alternative explanation. And then finally, I might think out loud with you about how the Catholic Church can both engage and temper this discussion. So first, it's clear from a reading of its social encyclicals that the Catholic Church has been a leading player, or at least interlocutor over time in the human rights debate, and has been for an amount of time that scholars could happily debate, whether that goes back to the first encyclical Rerum Novarum or long before that. It's not only the social encyclicals that we note today, Dignitatis Humanae, Pacem in Terris, Gaudium et Spes, but many, many others. This is additionally evident from the Church's steady labor at the United Nations, precisely using the rhetoric of human rights, and through its nunciatures in countries around the globe, by its overwhelming charitable and educational presence in developing nations and impoverished places in the U.S., and in the stream of conferences you may or may not be aware that are hosted by the Vatican both in Rome and around the world on major human rights concerns, some of the most recent, for example, being on human trafficking of women in particular and on immigration and the rights of refugees. In the current political, legal, and moral struggles over contraception, abortion, and marriage, however, the Holy Sees and the Catholic Church as a universal presence as church, their human rights bona fides are questioned or denied. I must say, as a person who participates regularly for the Holy See at various international conferences or at the United Nations, it is a little surreal for me. For example, and I can express, for instance, my work at the Commission on the Status of Women at the United Nations as a member of the Holy See's delegation. We will be called by various delegations, particularly the United Nations or the European Union, and then echoed by the New York Times or the Guardian newspaper or the Sydney Morning Herald. We will be called a violator of human rights, when at that conference we would have been working to establish a right of family reunification for migrants and refugees, for example, or pursuing a multinational high-dollar commitment to women's education in developing nations, only to be opposed by the United States or the European Union and being called a human rights violator while seeking those things. Why? Well, because we would have opposed establishing an international right in every country to abortion, which right was claimed to be in pursuit of the good of poor women, even though it was the poorest women delegations from the poorest countries that would oppose that right being impressed upon them. So one constantly finds oneself in the midst of that sort of situation. The outcry against the human rights bona fides of the Catholic Church internationally is often seen in efforts, often led by a non-governmental organization, an NGO that calls itself Catholics for a Free Choice, closely working with the Center for Reproductive Rights and Policy at Columbia University and the International Planned Parenthood Federation to strip the Holy See of its role as a permanent observer, to simply remove its voice from this forum. These efforts have thus far failed, and in fact there's been a resolution from the United Nations to affirm the good and the status of the Holy See as a permanent observer. The outcry against the Church's positions on human sexuality is also seen in the recent move, you may have noticed, it was in all the newspapers, by the United Nations Commission on the Status of the Rights of the Child to place on the same plane the obvious wrongs of some of the Catholic Church's response to clergy sexual abuse on the same plane with the Church's teachings about respect for unborn life or for marriage, etc. These were actually identified as equal problems by this commission. At the national level here in the U.S., there's emerging a legal regime which treats Catholic doctrine and practices in these areas as a violation of human rights. What are some of the characteristics of this regime? Well, you'll see in the law that when religious people are engaged in worship or the communication of doctrine, that is, when their audience is strictly co-religionists, then Catholics would be permitted by law, and other Christians usually, to act in accordance with their teachings about human sexuality without running afoul of the law. But as soon as the Church encounters the wider public, whether as a client or as an employee, the Church at that point must bow to a law which is formally religiously neutral on its face, but burdensome as applied. And it must take actions that violate their religious beliefs or withdraw from the public square. This dynamic means in practice that Catholic entities or individuals can be as follows. 1, denied licenses to operate as charities or public accommodations. You will have seen this in Catholic adoption agencies being forced to shut down completely in places like Massachusetts and Illinois after laws on same-sex marriage went through. There are many unseen actors who have also shut down. The adoption agencies were the most prominent. In Washington, D.C., a charitable provider of free wedding services to the poorest citizens of D.C. had to close down because they did not want to serve same-sex weddings in the same way they were serving opposite-sex weddings, but they were not allowed to give charitable services as a licensed charity that was tax-exempt and so forth any longer after D.C. had same-sex marriage. There will be a denial of tax-exempt status completely in some cases because that is a discretionary matter of the tax authorities, and these religious entities would be deemed to be violative of a public policy. They would be denied government grants for providing charitable services, even though they had been providing them before and successfully on the same basis as a secular provider of charitable services. So, for example, in the last couple of years, we've seen Catholic anti-trafficking concerns denied federal grants because they would not cooperate with a regulatory policy that included abortion and birth control, even though those Catholic agencies were voted by the government agencies themselves as delivering far superior services to the non-Catholic agencies that eventually did get the grants. They might be mandated to provide things that were contrary to their conscience. They would be required to recognize, say, in their employee benefits policies, marriage, a new meaning of marriage in a jurisdiction that divorces marriage explicitly from children or from the notion of male-female complementarity. In countries like the United Kingdom and Australia and Canada, we're also seeing a chilling of speech about religion by private actors, bishops, pastors, even would-be foster parents, if these actors intersect the public square in some way. That is, if they speak to the press or otherwise take a public moral position, for instance, about forthcoming legislation, or wish to share their faith convictions with possible foster children. Right now in the U.S., as seen in recent media storms over Arizona and Kansas religious freedom legislation, and even yesterday in the Supreme Court's oral arguments in the Hobby Lobby contraceptive mandate cases, there is really emerging a narrative which says that religious freedom protections in law are really a legal license to do invidious discrimination. So now to the top-line story, if you will, of how we came to this place I have just described. This story claims that we're witnessing the triumph of a later 20th century feminism, which had prioritized, in particular, available contraception and legal abortion, and that we are seeing the triumph of the LGBT movement, perhaps especially after they were galvanized to public action after the AIDS epidemic of the 1980s and 90s, which crisis also secured public solidarity for this group in a very new way. We are also seeing both of these causes enjoying dramatic levels of support, in particular from very influential groups, from wealthy Western nations, from the US and the EU, from Oceania, increasingly from Latin American countries, as well as from leading privileged institutions like academia and the media and the entertainment industry. Part of this top-line story is what these groups have triumphed over. And in the context of the Catholic message, this would be their triumph over what they characterize as Catholic positions in these areas. And you don't have to go too far to find their characterizations of what they believe Catholic positions are, what their doctrinal and public messages are. The first would be their belief that the Catholic Church is promoting the intrinsic inferiority of the woman, a status and identity discrimination. They would also say they are promoting the intrinsic inferiority of homosexual persons, another status or identity prejudice. That the church is promoting biological reductionism, that woman, for instance, is child-bearer and child-carer and fit for nothing else. They would say that the church is promoting the notion that sex is intrinsically low or disrespectable. Last week, Slate magazine, for instance, called the Catholic Church opponents of sexual modernity, generally speaking. There is even the notion that the Catholic Church is an enemy of modernity altogether, as captured, I think, perfectly by a comment made by Lord Warner in the House of Lords in England just a few days ago, calling opponents of legal abortion or assisted suicide, quote, residents of a civil society Jurassic Park. I'm going to suggest an alternative explanation for this conflict. I believe there are a few other things happening than what I just described. I believe first that groups opposing the church's public positions in these areas are making very effective use of human rights themes, concept, and language that are certainly and prominently featured in the kinds of documents whose anniversaries we note today. And in my written paper, I will go paragraph by paragraph through these documents, through the UN's document on economic, social, and cultural rights, and Pacem in Terris, and Gaudium et Spes, and the civil rights laws, et cetera, and show that the language and concepts they're using are very well found in there. They are grounded in those places. On the other hand, however, these groups are focusing on only some themes in these documents, which are indeed there, as I said, but they are neglecting other themes which are just as prominently featured in these documents. They are focusing more on rights that are in the framework of individualism and materialism. In the matter of individual rights, you will see that the groups asking the Catholic Church to leave the public square, and I'm reminded I was in a debate with a lawyer from Columbia from the Center for Reproductive Rights and Policy. She said to me simply, your voice should have no place in the public square. It's none. It's on tape, or I almost wouldn't believe I had heard it. They think that their focus on individual rights and rights to material progress for people are really the only things in those documents, and that voices against that are simply in complete contrast to what those documents stand for. When you look at what they say in their briefs before the Supreme Court, in their testimony before legislative bodies, in their public relations arguments, their arguments are very clearly about the emotional desires, for example, of LGBT individuals for a particular kind of respect and approbation from the state and society of their emotional and sexual intimacies. They wish the state specifically to overcome past real discrimination against the LGBT community explicitly by granting marital rights. When these briefs and testimony and public relations statements are made about women, they are about the rights of individual women to particular things, not women in the context of relationships or in the context of particularly family or with children, but her interest as an individual. When they speak about rights to material goods, again, these do echo important themes in the documents we note today. But they focus on these, again, in a very explicit way that doesn't reflect other rights also stated in those documents. In the birth control and abortion context, they argue specifically that women's very access to society, her access to education and jobs and money on terms equal to men, it has been built upon women's access to birth control and abortion. They argue with particular fervor respecting the good of access to both for the poor in order to make their educational and economic opportunities greater without children to care for, and in order particularly to ease their economic cares from too many dependents. In the case of same-sex marriage, they argue for same-sex pairs' access to very specific government benefits that are provided. But what do they omit in their focus upon material and individualist goods? They leave out the good of the family, founded upon marriage, and the duty of other citizens in the state to support it. They leave out questions about parents and parents' rights respecting children as a function of parents' duties first to children, that their rights are a function of their duties. This is captured brilliantly in Blackstone and really was a theme sounded by our Supreme Court in every single one of its cases treating both marriage and parental constitutional rights up to the present time where it has now disappeared. They leave out the rights of mothers to social support, commensurate with their needs in connection with pregnancy and family care work. An inflection point in the sort of avoidance or not mentioning at all of these topics really were the United Nations conferences on women and on population and development, popularly known as the Cairo and Beijing conferences, where these terms, the good of the family or parental rights or the rights of the mother or the state's deference to marriage and the family, these were all deliberately, very carefully excised out of documents and objected to when they were attempted to be put in, even though they had very well appeared in the Declaration on Human Rights from 1948 or in the documents on economic, social, and cultural rights or in Pacem in Terris, et cetera, et cetera. So I think the imbalanced focus of on some of these rights, to the exception of others, is part of the explanation as to the inability of some groups to see what the Catholic Church is promoting here as having any part of the human rights promotion of women or marriage. I think these groups are also uncritically embracing technology, even though its effects upon human ecology are really being called into question today. They very often equate technological progress with human progress in the name of the freedom of persons, in the name of their material welfare. I think the best response to this is probably in Caritatis and Veritatem, with Benedict actually taking up, Benedict XVI, what progress actually means, and it is not simply the new iteration of whatever technology we already have. I think they also are refusing to reevaluate their positions in light of broad social and cultural and economic changes that have happened between the 1960s and today. And I don't have time to mention all of these, but I think some of these economic changes that have to be mentioned that I don't believe they've fully accounted for, including their impact upon women, upon human sexual relationships, and upon marriage and the family, include economic changes which invited women into employment alongside very little adjustment of the educational or employment arenas to accommodate the caretaking that women disproportionately do. I think they did not at all expect the radical changes in the situation of relationships between men and women. In the 1960s, it was taken for granted that most people would marry, that they would seek to have children within marriage, that marriage was a status that one sought, and it had its own expectations that one sought to rise to and to fulfill. And there was an understanding that you would make it or try your hardest to make it last or persist. But today we find instead that while aspirations for marriage remain high, gender mistrust has risen, there is less marriage, there is more cohabitation. Marriage has become more of a luxury good, signaling one's personal arrival to achieve more or less enforceable trust from another person. This is brilliantly described in the work of sociologist Andrew Cherlin. But it has also become a much more fragile institution. And we find that there is a gigantic gap between the rich and the poor. The poor feel no longer that this is an institution that people naturally enter, but rather that it is a luxury good that only people with more money and education can afford. We find that while people have aspirations for children, they are no longer axiomatically connected to their aspirations for marriage. And we now are at the point where we have a 42% out-of-wedlock birth rate in the United States, and we are now over the 50% mark for out-of-wedlock births for women under 30 in the United States. These, I think, were unexpected changes that the rhetoric of those who would, again, excise the Catholic Church from the human rights arena are not fully taking account of. Further, they seem not to be willing to grapple with the empirical data, whether it issues from the World Health Organization or the NIH or academic journals, or the qualitative and quantitative data on the family, coming from scholars like Mark Regnerus in Premarital Sex in America, Donna Freitas on Sex and the Soul, Lost in Transition, Promises I Can Keep, Why Poor Women Put Motherhood Before Marriage by the amazing sociological team of Eden and Kafalis, or their new book on men, which is Doing the Best I Can, Why Men Will Have Children Out of Wedlock. They are not grappling with the economic literature on risk compensation, showing that embracing an uncritical approach to sexual freedom that includes contraception and abortion outside the context of relationships and marriage has actually led to higher rates of unintended pregnancy, more out-of-wedlock births, which is the #1 correlate of poverty, a greater gap between the rich and the poor when it comes to marriage or childbearing, and the immiseration of women generally, who, although they would like to marry and avoid cohabitation more often, and they would like to have children in marriage, and they would like to avoid abortion, find themselves doing much more of this than they did in the past before, in particular, legal policies began to support widespread contraceptive and abortifacient programs in the name of women's freedom. The overall result of an over-reliance on technology, a failure to account for the empirical data, or to take into account the massive social changes that have gone on between 1960 and today, is that I think the positions of those who would grant the church no role in the human rights arena in these areas are insufficiently attuned to the good of relationships, the good of relationship with God and with other people. They are insufficiently attuned to the meaning of life as love and service in communion with others, as has been referred to so many times today previously. I would note here that it is very, very hard for me, and I think for others, to make this critique convincing in public exchanges about the intersection of human rights and Catholic beliefs and practices. Not because the human rights documents we recall today would not make these critiques, I think they would, but because our times have become, and I think Stanley Hauerwas referred to this, so very, very accustomed to an individualist materialist, not a transcendent or community-oriented or service and sacrificially oriented understanding of the meaning of human rights. Now, there is somewhat miraculously, in my view, a continuing robust debate about the emerging situation of human sexual relationships. And I think this is amazing that it is even happening at this time. It is emerging that the groups who are allegedly the primary beneficiaries of the new dispensation on sexual relationships are not faring well as a consequence of them. Yet the groups sponsoring this new dispensation are not really responding to the empirical evidence, the empirical critique, which is becoming a resounding critique in family law and particularly in family sociology. Why is there no thoughtful response to this? Why is there no grappling with the empirical data in particular about what holds together the economic, the spiritual, the psychological, and the sociological well-being of people, particularly the poor, particularly women, particularly minority and immigrant groups? I propose that an important reason is a commitment, which is kind of fideistic, if you will, to something I would call sexual expressionism. There's a development economist, Lant Pritchett at Harvard, who refers to it as sexualityism. The idea that human freedom and equality does not lie in relationships, in communion, in mutual regard, in service, but rather in a freedom to engage in sexual activities of any kind so long as they're consensual, okay? You can see this in the opinions of the United States Supreme Court, in the expressions of beliefs of relevant NGOs. It's certainly more muted at the United Nations. Attempts sometimes are made to make that statement, but they are usually pushed back by a combination of the African countries, Central European countries, a few Latin American countries, and most of the Arab-speaking countries. This is a commitment to a particular view of the meaning of human sexual relationships. Here, the idea that the Catholic Church or others would interject into an understanding of freedom in the context of human sexual relationships, the meanings like the other, like the relationship between sex and the conception of children, like the intrinsic embodiedness of the human body and its complementarity between male and female. These are really anathema to a sexual expression understanding. The current marriage, if you will, between LGBT groups and abortion providers in favor of the message that all advances for religious freedom are at the costs of their agenda, when these groups' agenda are not really explicably overlapping, except to the extent that they would both sign on to the notion that identity formation, personhood validation, universe shaping, in the language of our Supreme Court in the Casey opinion, are all done by sexual expression, which is held to be a very, very central part of who the human person is, of what human identity is. So my final point is how the church might grapple with this insistence upon vaulting sexual expression, shorn of relationships sometimes. Sometimes they link it a bit to emotional relationships. But how to grapple with this insistence upon vaulting this to the center of the human rights agenda, such that Catholic religious freedom and voice should be cabined. Now, this could be the subject of a lengthy tome in very many disciplines, right? Theologians might look into the area of original sin to explore the foundational denial of what God has made concerning male and female human natures. A theologian might look to his and her effects of original sin. They might look to the dialogue between God and Adam and Eve after the fall and know that the male-female relationship would be the site of particular difficulties. Theologians might explore St. Paul's expression and John Paul II's scholarship regarding marriage as an icon of Christ's relationship with the church even, and of human beings called to love in communion overall, not just in marriage. And a theologian might ask then about the likelihood that evil, in order to strike at both our understanding of God and the essence of human love, would afflict human sexual relationship particularly. A sociologist or economist might consider that in a world of fewer freedoms in light of increasing state regulation and global effects upon even small localities, sexual choices are one of the few areas left in which one can affirm freedom, distinct from state regulation. Economists might simply point to the technology shock of the pill or legal abortion and its effect upon marriage and relationship markets. Lawyers and sociologists might point to the state's withdrawing itself from supporting marital stability or the ongoing relationship between children and both of her parents. But the question still remains, how might the Catholic Church respond in this environment? And I will just offer a few points, all of which could be expanded greatly. The Catholic Church has, throughout all of the development of this conflict, continued to devote considerable intellectual firepower to subjects of human sexual relationships, marriage, women, and the meaning of freedom. John Paul II's letter to women, Mulieris Dignitatem, Familiaris Consortio, the Theology of the Body series, the Francis's collaboration of men and women. This has been ongoing. They have continued to learn about the human condition from their human services experiences, where they see the effect on the ground of ideas that have taken place in law and culture. They will continue to, therefore, affirm what they can where the church intersects the world about human rights, the freedom of women, the freedom of families. They will reaffirm everything they can in this area, such as the strategy they took in Beijing to affirm everything that was good about human rights for women in that document, but then draw a line. They will continue to engage reason, to hold international conferences on these matters. They will attempt to engage people winsomely for on these topics. They will attempt to take advantage of St. Augustine's observation that truth is like a lion and it has its own power, and they will continue to speak out about it. But I am the first to acknowledge that the language they need to use, they have not yet perfectly found and have a long way to go. They will continue, and then should also improve, to model good things at the church. Look at Francis. We are very much the center of attention now in how we live inwardly. They need to model complementarity better so that when we're calling for it in the world, people might understand through us what it looks like. And they need to, of course, call on people to maintain personal witness, what our ethic of human sexuality and women's freedom and family looks like. There is going to be an opportunity to do this, maybe even as against increasing state pressure not to. So stories of witness may become more prominent even as the state is exerting more pressure upon individuals not to show it. None of these are absolutely convincing silver bullet answers to the deep conflict that is going on in the world between contending notions of religious freedom. But all of these are things the church is presently doing and is evaluating at this very moment how to do better. Thank you very much.
If truth is a lion, we've just heard a mighty roar. That was an extraordinary tour. Thank you so very much, Professor Alvaré, for opening this world to us, for sharing your advocacy, your passion, and the stakes of the battles that we're now facing at the edges of family law, of human rights, of religious freedom, and more. We have a few minutes to take some questions from our distinguished panelists. I know time is waning, energy is waning, beer and wine are going to be served soon, and maybe what we can do is take a few minutes to entertain questions from the floor. If our three panelists want to put questions or comments to each other about this peroration we've heard from Thomas Aquinas to the latest of Vatican law, all of those interventions amongst the panelists and from the floor are welcome. Any comments to each other, or should we just invite our friends to hold forth? Let me again start on the left, again with no commentary. Ms. Savage.
My question is primarily for Professor Alvaré. Thank you all, first of all, for your comments. They're very insightful. I'm thinking about your opening comments and your beginning comments on the hostility that the Catholic Church has faced on their stance on certain social issues. And it calls to mind a question my friend asked me a while ago about the reason that Christians and Catholics perhaps don't have a voice that wants to be heard is because of our reaction to certain social issues. Not so much on the macro level that you operate at, but maybe the micro level. When they see busloads of church members gathering to protest against same-sex marriage in California, or they see rioters and protesters, or they may see them as rioters, protesting outside of abortion clinics and yelling at women who are making that choice. It seems to me those kind of images, that kind of dialogue may be what is keeping people from listening to a Catholic message or a Christian message for social justice. So I'm just wondering your thoughts on, is there a better way, and not just for Catholics, but for the Christian community as a whole, to re-engage everyone on a level that shows a little bit more, maybe more compassion, so that the message can be heard and perhaps change hearts and minds?
Thank you so much. Couple things. Number one, the preeminent work of the Catholic Church in this area, having been part of it now at the level of the international and the national and the local church, the preeminent work is not protest. I think at this point, Catholics and other Christians together have, I think, 3,300 crisis pregnancy centers and are the single largest private provider of services to poor mothers, not only in the United States, but around the world. So we know that good news does not go far, right? It's not what I get called about to go on CNN about. And so it's very difficult to manifest this when most people don't get their news the way you're getting it right now by going to a high-level conference on a topic. Second, if someone doesn't want to see people protesting at all on an issue, it may be because they have a pre-existing, they don't want to see them protesting on a certain side of an issue against same-sex marriage, or they don't want to see them outside an abortion clinic because they've already made their mind up about that. So it wouldn't matter who was in that protest, they would be upset about it. I have no idea what percentage are Catholics or other religions or non-Catholics. It's not the face of the church so much, and it's not what we send out instructions or material about, which are mostly about charitable services and sort of the intellectual, both the natural law and the theological statements on this. The last thing I guess I would say is on the question of marriage. I think on the question of abortion, it's not difficult to put out a message that touches people's heart pretty quickly, because we know that most mothers would like to be assisted to take care of both themselves and the child in that context. On the matter of marriage, it's been framed in a way that I think those who would like, who don't want to see legal same-sex marriage, but who would like to preserve some special place for the relationship that links a mother and father to their child, don't have anything near the equality, the equal sign, or a quicker way of expressing what they're trying to do. Here's an example, I think, where the earlier panel that talked about the impoverishment of the language of rights, that's what we're really running up against. Because marriage equality as a right, or marriage right, et cetera, is very easily stated. But the question about whether or not there ought to be some special state endorsement or promotion of the relationship in which kinship, child's relationship with mother and father, the larger family takes place, boy, you can't put that in a quick sticker or in the word of a right. Thank you.
Any other panelists? We'll go to our right. Mr. Webster.
My question is also for Professor Alvaré. I want to thank you so much for your remarks. And as a fellow lawyer, I really appreciate your valiant defense of the Church's position on human sexuality and human rights. However, I need to ask you a question, which is really a softball question. I'm sorry about that. But
go right ahead.
Here
I almost never get softballs. So I never, actually, so go right ahead.
Me neither. But here in Atlanta, we have long had a deep love for the Bride of Christ. In the Civil War, we had a heroic Irish Jesuit priest who persuaded General Sherman to not burn down 5 churches plus the Shrine of the Immaculate Conception. For 100 years after that, the church did very, very good things here in Atlanta. But for the past 30 years or so, the Bride of Christ has strayed from the groom on several occasions. First, we had a priest who was convicted of child molestation for several altar boys who hid out in England and had to be extradited here for trial. We then brought in a new archbishop to try to contain the problem and clear it up, and in the process he had a 2-year affair with a mistress who was a singer and a lay minister in the church who claimed that he had married her in a private ceremony. She also claimed, it turned out to be false, but that another priest in Columbus had fathered her child, and the church was paying child support payments to her and giving her financial assistance while her affair was going on with the archbishop. After that, Catholic Social Services had a scandal because they had placed several refugees here in Atlanta from Romania in other countries in some squalid conditions, and it turned out that the director in Catholic Social Services wife was a co-owner of these apartment complexes that had practically been condemned. The director of social services made the comment publicly that these refugees were responsible for their own squalid living conditions. She resigned.
Let's put a question, please.
Okay, I'm getting there. And the last part of it is that we now have an archbishop who has built a $2.2 million mansion. In light of all of this, the arrogant appearance of some of these things that the church has done, can Pope Francis, can the Holy Father regenerate the church? Can he rebuild the church? I mean, how are we going to offset this image that the church has of not really taking care of people, but looking after itself?
First, I apologize to my other panelists that I often draw so many questions because I'm dealing at a controversial leading edge. A couple things. Number one, I headed up the investigation into child sex abuse in Philadelphia, so I'm familiar with this side of the church and hope to have been part of bringing justice back. And what Professor Whitty said earlier about the Pope's introduction to the meeting that he recently had about repentance coming first. John Paul II did it constantly in his documents, especially ahead of the millennium, is always going to be necessary for us. Number three, with respect to Pope Francis, it goes back to number one, which is I was a part of a commission that tried to help rout out bad practices in Philadelphia. We need to be decentralized on this, right? The Pope is saying, I'm actually not going to fix it from Rome. I'm going to set an example. I'm going to be what I have come to understand as the Marian face of the church, which I sometimes refer to as the merciful, loving, wayward child calling, birthday card sending, call your mother version of the church, and he's actually calling you and me and others to go to the front lines of this work. I am ecstatic about his call for simple living, for repentance, for a dialogue about women and about inequality in the poor, as having been off a great deal of political radars for a long time. And so if we cooperate, if we like what we're seeing, then I think he's saying, from Rome to the National Bishops' Conferences, from the dioceses to the people, he wants you and I to actually be a part of this reform. Thank you.
I want to apologize. I forgot. In the interest of full disclosure, I'm a lapsed Catholic, but I still have a great love for the church, and I think that Pope Francis is a rock star.
Thank you.
Professor Porter.
I want to say a couple of things very quickly. The first is I think you have to put on the table that the governance structure of the Catholic Church is practically unworkable at this point. It is organized formally on top-down lines that are just not going to be workable. I think that you're absolutely right that we have scandalized people in the literal sense to our handling of the sex abuse crisis, and I don't think it's wise for the Pope to try to say that he cannot take direct responsibility for that. I think there's a grain of truth in the United Nations Rights Commission on the Rights of the Child saying the Holy See does have responsibility here because of our institutional structures. And to go back to the last question, I think that the whole history of the Catholic engagement in these issues in this country is very messy, and I think there's a lot of grounds for complaint on all sides. I agree completely that it's ridiculous to expect us on rights claims to change our fundamental doctrines or teachings. I think we have grounds to question them, but I don't think those are it. I think we should be scrupulous in protecting the integrity of the church itself and institutions with a religiously organized point. But some of the recent activities of the bishops around this area really have again scandalized people. I think the direct and heavy-handed involvement in political processes has been deeply troubling to a lot of people. Extreme applications of the abortion rule, excommunicating a nun who allowed an abortion in the case of a woman's life being in danger. People, these may or may not be defensible, but people see this and they don't understand. And saying that is in no way to deny that there's plenty of nonsense and invidious argument and bad acting on the other sides of these debates. I just think that it's a complicated and messy controversy that's going to need to be sorted out very slowly and very carefully.
I want to agree with Jean on this. Once upon a time, not that long ago, a lot of these issues of church misconduct would have been handled by the state. In other words, if you had gone to 18th century France and you have a problem of pedophile priests or fraud being committed by the church, I'll tell you who would have handled it. It would not have been the Bishop of Rome. It would have been Versailles through the instrumentality of the bishops of that national church. So one of the prices to be paid for more radically claiming the liberty of the church as against these sovereigns is that now the responsibility is on that part of the church. You can't pawn it off to Versailles or to Vienna or something like this. And in the last 50 years, especially on the pre-scandal, especially there, the church has not used well and responsibly its own liberty on this.
Thank you. Let's collect 3 more questions. Professor Hammond, good to have you back, sir. One of our proud alums of our Law and Religion Center and now a tenured professor in Alabama. Good to have you, sir.
I apologize in advance to the other 2 panelists, but my question is for Professor Alvaré. Now will be the 3rd time that the Hobby Lobby case has been invoked in today's proceedings. And I want to ask you, Professor Alvaré, if our nose counting goes awry and the Hobby Lobby plaintiffs lose, what do you think that will mean for engagement in broader society by Catholics?
We can collect 3. That'd be great. Thank you, Madam.
This question is for Dr. Porter. I wanted to ask you, actually going back to the last panel, the question of translation, or what we were calling translation between different religious groups and different sort of cultural groups. I'd like to ask you just to speak a little bit about how your conception of natural law and natural rights, if I get this right, is expressed but not sort of fully expressed in any given cultural and legal order. And yet it can be expressed in many different ways. I wonder if you could just talk a little bit about when we have global conversations about human rights, what does that conception of natural law and natural right mean for the possibility of this kind of translation among various groups and cultures with different, again, legal orders? Thanks.
Thank you. Let's collect the 3rd question and then put that to the panel to both answer the questions that they wish and to make any final comments as we begin to wind down. Please, sir.
I want to thank you. I'm sort of an outsider here. I really appreciate the public being included in this, and I want to thank you and the McDonalds for this. I'd like to sort of connect the early lectures with the later lectures. One of the things that they talked about was the difference in the language of obligations and of rights. And I think particularly Dr. Alvaré, but has talked about the language of rights here. And I admit I'm a non-Catholic, a non-lawyer, and a non-theologian, but it strikes me that the language of obligation should be worried about how we love these people, how we love people who are same-sex couples that have lived together all of their lives, and all of a sudden at the end of their lives they have no rights in a situation where one of the partners is dying. About Catholic women who very much would like to be leaders in their church, but are by doctrine excluded from the church. I think you've touched on this a little bit already with your comments about abortion, but again, about women who are in desperate situations. Dr. Porter mentioned the nun that was excommunicated. But what about these women that are in desperate situations and aren't being properly taken care of. Don't we as a society and we as a church, and I'm talking about all of us together, have obligations to these people?
Thank you very much. We have 3 questions on the floor and broader thematic issues that we want to engage at the same time. I will let you speak in whatever order is comfortable for the 3 of you.
Well, I will take care of the wonky question. And then we can get back to the events of the day. Actually, I think it's a critically important question. The question, as I understand it, is the question of how you hold on the one hand, to the idea that there are certain fundamental freedoms and immunities that every human being enjoys and ought to enjoy, and on the other hand, to acknowledge the necessity for conventional expression of these in some points and up to some, and in some ways. I think that the importance of that really is illustrated by Nigel's remarks. You know, Nigel perfectly represented my position, which I have not changed. I think there are some kinds of acts which are not morally justifiable under any circumstances, and I think torture is one of them. I think it is possible to give a non-formal understanding of what counts as torture, sufficient to rule out many, many anticipated courses of action, always acknowledging that there will be borderline cases in the application of any general moral concept. So how do you arrive at that kind of hardline conclusion when you also think the natural law and natural right call for some kind of conventional expression? This would be my point, and I would go back to what I said earlier about the way in which the scholastics parse the language of rights. The fundamental idea is the idea that the moral personality of the human being includes, at its ideal, a capacity to make authoritative claims on others, to act as an individual exercising one's own moral powers. That claim is exercised in the light of certain kinds of rational justifications, which are in principle similar to the justifications behind legitimate legislation, the jura, the rights which are grounded in various considerations. Now, the ways in which those rights are claimed authoritatively and balanced is going to depend to some extent on the moral ecology of different communities. You're going to have different formulations of gender relations, different ideals of judicial procedure, different ways of arranging property. All that, I think, is quite legitimate. But I think there is a test for what is illegitimate, and it would be this, that a particular understanding of a moral norm or a set of social arrangements which effectively rules out or gravely impairs the capacities of people to act as agents in their own behalf is, I think, impermissible. That, I think, is the ultimate argument against torture. I think it's the argument against the denial of what are sometimes called due process norms or norms of proper legality. It's the argument against, it's the ultimate moral argument against slavery. So I think this is something that does moral work. Now, it does moral work at the level of the extremities, but our own experience should teach us that when we're scared enough and desperate enough, moral courses of action that we would have ruled out of court suddenly become, in our minds, not only permissible but downright necessary. And not only necessary in extreme cases, but something to be incorporated into regular state policy. And I have to say, I find that profoundly troubling, and I hope we can think more about what we're saying here.
So I'll take the last 2 questions in reverse order, if I might, and end with the legally wonky stuff on Hobby Lobby. The questions about rights and obligations as applied to the 2 scenarios that you put forward, which would be like recognizing same-sex marriage, especially couples who had been together for a while, or women as priests, they are, I think, in distinction from the framework in which we've been talking about rights and obligations here to this extent. To talk about human rights of persons, no matter what their status, male, female, member of the LGBT community, race, national origin, et cetera, is one thing. But the legal argument, which is also a cultural argument over marriage recognition by a state, means what does the state value in marriage? If you look at 100% of Supreme Court cases right up to the one that was issued in Windsor, the Defense of Marriage Act case. In every single case, the Supreme Court said what states had said up to that point too, which is the state has a particular value for relationships that have children, and we don't test people, that would be offensive, they said in advance, but male, female is a generally, a broad rule. States are allowed to adopt broad rules, even though every single situation may not meet it. Not every 16-year-old is ready to drive, and some 18-year-olds shouldn't be allowed, et cetera. But we adopt these broad rules to say what it is we value about marriage. That is irrelevant to statements about how we feel about LGBT persons. Now, what about LGBT couples who are doing something the state in a family law context has traditionally valued, which is in particular taking care of one another, like people take care, they're interdependent. Might the state wish to value that, but not say it is identical to what it is that we have in a male-female relationship, especially where there are children? They could do that. So legally speaking, what you're talking about in terms of their obligations to people, in the marriage context, what the state has said is, this is what we value in particular, and if you're doing that, then there will be benefits for that. If LGBT people as couples are doing other things the state happens to value, or a piece of what married people are doing, what about the state valuing that in a different way that is not marriage, calls it something else? It's certainly possible. In the context of women priests, there you're raising a theological question that is very, it's just huge, the literature on this. And it's not a human rights question in the same way that we've been talking about that today. It's a question of what the church thinks it can do. It's like that even if various cardinals or bishops, et cetera, or a pope felt that, I really would like to. I'd love to see that outcome. There are arguments that maybe it hasn't worked so great. But again, it's a theological question that's beyond the scope of this. And whatever side of that argument one likes, the fact of lodging that with the question of a human rights in the context that we've been talking about today they're very different kinds of debates. The question about Hobby Lobby, not to bore people here but there's basically three questions in that. Can a for-profit corporation have a conscience? Do corporations get to say whether they're burdened, or does the government get to say your conscience is or is not burdened? And the third question is, even if you are burdened in your religious exercise, does the state have a compelling state interest in requiring you to provide free coverage? And in Hobby Lobby's case, it was for 4 drugs or devices that can act to destroy an embryo after it's formed, which is not something the government can test. Kathleen Sebelius at HHS has acknowledged that these drugs and devices do this, so the argument is joined at that point. And if there was a win for Hobby Lobby, it would look like it was about 5-4, maybe 6-3, perhaps. If not, what would happen? There's several things that might happen. People who incorporate, who want to have a religious conscience, might not be able to offer their employees health insurance. That would be something that they simply couldn't do for their employees. Non-religious companies could, but companies that have religious convictions, especially closely held companies where we might discern it most easily, would have to send all their employees to the state exchange and say, I'm sorry, I know you're used to us providing insurance, but we can't. And they wouldn't feel morally good about that either, let alone their competitive position economically, but they might do that. In the case of the entities like Little Sisters of the Poor, Catholic hospitals, Catholic charities, they might do the same, or they might have to switch to being entities that would fall into the first sector of the regulation that says if you're out and out religious and you only hire and serve religious people, then maybe the government will give you an exemption. And they'd find themselves withdrawing from hiring non-co-religionists, and they wouldn't serve people who weren't co-religionists at that point either. So either way, there is a reduction of their ability to have public witness. There are various moral theological scenarios under which they don't leave the market entirely, but they change form and they become less visible.
Just a devil's advocate
Yeah.
question. Suppose it were possible and truly effective to get out of the business of insuring your employees and putting them into the exchanges. Why would this be objectionable to the church? Because, or to a person of conscience, since the exchanges are being set up to provide, as the government says, even better coverage.
Right.
And that's a way, it's not ideal because we don't have a congruence between our theological natural law beliefs and the human law, but we're not being forced to do anything dishonest or against our beliefs. We're just putting them into the general system.
Right.
Why not take that as a good compromise?
I leave to the moral theologians the questions of the moral theological implications, so I can't go there. But I can say from the perspective of, an analyst of the First Amendment, one of the questions you ask is, what is a substantial burden? One of the answers is that you are compelled to do something that others aren't compelled to do, so that it's okay if you want to be a religious person. There's a couple things. Number one, if you choose never to incorporate. So you might be able to get away with offering your own insurance. But if you want to incorporate, then unlike non-religious entities, you may never offer private insurance. They may say, wow, it's a competitive disadvantage in the market. But more than that, legally, they'd say it's the kind of coercion that perhaps the First Amendment or the Religious Freedom Restoration Act is designed to protect against. So I don't know the moral theological answer. I could prattle on, but I don't think I'd get far definitively on that. But legally, is that a cognizable burden that if you want to incorporate as a religion, you may never offer your own insurance plan? They may, it's under precedent, it's possible.
But to give an example of how
Let's
to put
make
it,
this a final comment, please.
I mean, in France, if you get married, you really have to do the sacramental marriage separately.
Yeah.
And the French bishops are not calling for changing that situation, that it's not a burden to the priesthood or to the married spouses to register civilly, and then if they so choose in their liberty to be married sacramentally, to do it under two covers. And wouldn't that be analogous to this business of the insurance?
Super quick response to that. It depends on where you are in the legal regime. If you're in a situation where the state is affirming the good of keeping men and women and children together, you don't want to be the initiator of a system that says, oh, let's take away the state's affirmation of that. No. You wouldn't want, but if you're in a situation which appears possible next year, 2015, where Justice Kennedy, because he has the swing vote on this, Justice Kennedy writes an opinion that says that same-sex marriage is a mandatory 14th Amendment right, and now you're in a position where you are more or less participating because of the church's ability to grant a civil marriage as well, then you may wish to withdraw at that point. So I just think, I'd have to think it further, but it depends on where you are in the legal regime, whether you'd want to advocate pulling the state back from endorsing complementary procreative marriage and separate marriage out civilly and legal and religiously.
But we have gone from 3,000 years ago, Genesis 1 and 2, two in one flesh, male and female he created them, be fruitful and multiply, ancient texts that stand at the head of the Torah, all the way through to the latest machinations by the U.S. Supreme Court and prophecy about the consequences of the same. Never let it be said that we are not comprehensive in the work of our Law and Religion Center, and never let it be said that we're ungrateful to all of you for being here, dwindling though you are, and especially to our speakers who take the time and effort in the beginning of the semester, the middle of the semester, and the end of the semester to edify us with their remarks. Before we go any further, I think we should, because we are of a small group, stand up and give thunderous applause to our three speakers this afternoon.
The preceding program is copyrighted by Emory University.